Bryant was in court this morning. We remember they were supposed to be in court either Thursday or Friday, or Thursday and Friday, or they picked a date. Well, they picked Thursday today, and you knew it was kind of important, even though it was supposed to be a motion just for. And you and I had this discussion earlier by text. It was supposed to be a motion just for her recouping her $12,000 in costs. As soon as I saw that Alan Jackson was there, I think I texted you, oh, that's not just this going on here. And so what happened, Michael?
Well, it really was technically just the motion for the $12,000 and change that the defense wanted back from the state, because, the Commonwealth hasn't spent enough money on this case. So they wanted their $12,000 back because they said it was only necessary to hire this expert, fly them out to Massachusetts to look at the magic DVR that sometimes does have video on it of the sallyport and those areas, and sometimes doesn't. Depends on the time of day and who's finding it. So they wanted this expert to come out and look themselves. And Jackson's point was that, if they hadn't screwed us over, that wouldn't have been necessary. It was something they caused. That was the technical part of the motion. But he spun this, and it really kind of genius the way he did it, because if nothing else, he's foreshadowing for the court what's coming in the motion to dismiss. He talked about all of these various Brady violations, in his opinion, Brady violations about the things related to these videos that have not been turned over, not been preserved, right?
Right.
Even though a formal notice was made twice to preserve this material. And there's kind of an unspoken duty to do that anyway.
Right.
Asking for it formally is just on top of that. And the Commonwealth failed over 3+ years to turn over this material. Dabbled into the Karen Read for a moment. You want to touch on that, or just save that for tonight?
Yeah, no, let's touch about it some more. Yeah, let's touch about it, because they're still out, and anyone have any questions on Karen Read, put them in there, because we will do some more tonight, obviously, a little bit more.
We decided not to go up this time, because even though there could have been something of consequence, and the argument was of consequence, the underlying motion was not so of consequence, the expense motion. But mark March 4th on your calendar, because that is when the motion to dismiss is going to be heard. And what kind of motion to dismiss is it going to be, according to Alan Jackson? Full-throated.
I always like that. I thought about a hummingbird, a full-throated hummingbird. He said that 100 times, I think.
It's going to be a full-throated motion. So
a full-throated motion. And then she gave the DA's office like 3 days to answer.
Well, they were negotiating, because here was the original order, right? And then I've made notes on it based on the changes she decided today. They're also having a hearing on the 18th about voir dire, just perspective questions, format. So that was going to be a day that was originally going to be for the filing of the motion to dismiss. That's been pushed because Alan Jackson cried. And he did it because he had just got dumped. How much did he get? What new discovery did he get from the prosecution?
A lot. Voluminous.
The word
was voluminous.
They got a voluminous amount.
Last night. You got a
full-throated amount of
voluminous amount last night that they had to do by link. Okay, and the defense was great. They didn't. Well, we'll be ready. We'll go through it. We'll be ready.
Yeah, it was 12 different files of stuff. So who knows? File is now they're all digital. A file could be a file. It could be a file. So anyway, that date was pushed, but she said, well, you already have the 18th available, because that's what we originally were going to. So that's the voir dire issue. The 21st is the new motion to dismiss deadline. It was going to be, like I said, it was the 18th. Oh, you know what? I think she pushed it a second time. Remember, because Alan Jackson said, can I get to March 1st or something, because we want the weekend.
He wanted the weekend. She said no, because I need weekends too.
Yeah. So it might have been, let me check my calendar. It might have been pushed to the 24th, which would, 24th gives them the weekend. So it is now the 24th. And
they didn't get the weekend. She wouldn't give it the weekend.
Oh, she wouldn't give that one? I think they have it on. I'm going to check, but I think I have it on the 24th. But
I thought it was the 22nd, and then the prosecution.
Well, it wasn't going to be 21st. 22nd is a Saturday, and then
I think it still stayed the 21st, and then she did the prosecution because she said she needed the weekend, 4 days or something like that, or they got 4 days, and then she wanted the weekend. She wouldn't give the prosecution, so she said she needed her week, and she needed her weekends, right, to look at the stuff.
So March 4th is whenever those.
And she has a hearing too. She has another hearing in there. She
She
gave
a
them.
hearing on the 6th for all reciprocal discovery. That's not a hearing. That's just a
Then she
discovery.
had a hearing on expert voir dire, I think, too, right?
That's why I said voir dire. That's on the 18th.
Voir dire. That's on voir dire, right?
That's voir dire.
Why would you have expert voir dire? What's different from voir
I
dire?
don't think it was expert. I just thought it was
But
just thoughts on the voir dire
on voir
process,
dire. Okay.
how
Okay.
they were
Got
going
it.
to handle
Yeah.
it.
Oasis
Because that we know that's
Capital.
coming up. That'll be April 1st. You know,
Yeah.
the first day of trial is. People think it's opening statements. It's not.
Oasis
The
Cat
jury
thought she gave
selection
them
meeting.
one more day to get their
One more
briefs.
day. So
One more
that would
day.
be the 19th.
19th is a
No, I'm sorry. That would be the 22nd. Is that right? The new date?
Yeah. Is that
No, that's
Saturday?
a Saturday. It can't be.
Yeah.
Can't be Saturday. Okay. Well, it's been pushed, and it's either the 21st or the 24th, and
Somewhere around there. Yep.
and then the Commonwealth has a few days, but the key is March 4th. That's the hearing.
And Jackson said, and we can argue it, and we'll be ready for trial. So no one's expecting it
Yeah.
to be granted, even though it's full throated. I don't think, because they said,
Yes.
of course, I don't know. Yeah,
of course. But then you've got just one more grounds for appeal, and just playing the game. But I think it's going to, just as today's argument did, it really lays the groundwork in front of the court and the public for all of the evil deeds by the prosecution in trying to hide the ball from the defense. And just ask the Baldwin folks how that played out for them. Morrissey, the DA in the Baldwin case, when they decided certain bullets would be relabeled as another file and not given to the defense. Oopsie. Dismissed with prejudice.
Moon God doesn't think it's going to go to trial. Making accounts is why didn't she seem to make any decisions from the bench? She did make the not guilty yesterday from the bench. Penny McGee. That's the one thing.
Yep.
That's the one thing she did. But that, my view of bench trials when defendants agree to them is usually because there's already been an in-chambers conference where there's you're not taking the jury to begin with, right? So you have to know how the judge feels about your case. There's a lot that we don't know when we see a case go to a bench trial on that, but yes. I don't know. You think, well, yeah, Alan Jackson's not going to say, he's going to say full throated, but there could be a lot of stuff in there. I mean, I can't imagine how you can have all these motions to preserve. And then it turns out that, and I'm going to go back to a comparison between here and ASAP Rocky and here. Brennen took this case as special prosecutor. He doesn't need it for his reputation. He's got a good reputation as a defense attorney. But now he's finding out all of this stuff that happened. If this were me, I'd be like, I'm out of here.
Yeah, that certainly he would have his. I could see him having the right to do that, but he's sucking it up, and I agree. I don't think he's doing it for the money, and we know the $75,000 that he's getting through June. Sounds like a lot of money, but it's not. Not for the kind of work and hours that he's putting in. I do believe he's a stand-up guy when it comes to, hey, I inherited this crap. Whatever happened before me, I take responsibility. I'm now the guy. I respect that. And he said that in court today.
Yeah, well, he did say that, but he was confronted with a whole bunch of bad.
Sure.
Stuff
Now, what he knew before he took the job and what he didn't know would be very interesting to find out. Because if he had done a little of his own due diligence, maybe he would have asked, a handful of questions like, anything we haven't turned over to the defense yet? Right. Oh,
and then by the way, there's a detective's file, because when you go ask for discovery, what do you ask for? What's in the police files, right? But the detective, and I always try to do this, a side file that a detective keeps, and they may have a download, and then where did that go? And then there may be an iCloud account, but no one knew who owned the iCloud account. Was that a formal account by the police? Was that some other side account? Personal account that somebody has other stuff in and other things. I mean, and then they went to, we'll talk about tonight, but they went to a sidebar. She asked about the federal investigation. So we're going to talk about tonight because you have the clip ready for that later on. When we talk
it's a clip of nothing, but it just does set up this conversation they had. It was a 14-minute conversation, sidebar, about what do we now know. That was really the crux of it. Are we going to get into this? She's asking, and this is the ARCCA, material, which is the federal investigation into whether or not there was, I guess, contact between the car and John O'Keefe. That, in a nutshell, that's what it was about. And so she wanted to know from the attorneys, well, where are we on this? And let's talk about it off the record. That's about as far as it went. And then for 14 minutes, they're talking at the bench about whatever it is they know about those reports. And clearly whatever she's learned is going to color her decision on what is and isn't going to be allowed in trial number 2.
Yeah, with the beep, beep, beep that we kept
Yes.
hearing instead of
I
the
said,
white
what
noise.
is that? I thought it was my pacemaker.
Yeah, I know, Dizzy. There's no such thing as professional iCloud account, so that's why no one seemed to know. Even Brennen didn't say, he didn't know what iCloud account it was.
That person was identified in the affidavit by Brennen, because the court confirmed, did this person you identified in the affidavit, they're the one who uploaded it into their iCloud account, which is now where they'll go to get it.
Fun to see. So TB, It's a Beautiful Life. A lot of people get confused about reasonable doubt. Can you explain how reasonable applies in the Rocky case, even though people get stuck on the he had a gun fact in the case?
Interesting.
Go ahead, Michael.
Well, he had a gun, maybe one element of the ultimate crime. Obviously, you can't shoot at somebody unless you have a gun to do that. So that's fine. That's an element. But the reasonable doubt, I think the question is, what is reasonable doubt? And if we compare it, sometimes I used to have some sticks that I used to use where I would have clear and convincing evidence stick. I would have beyond a reasonable doubt stick. I would have a preponderance of the evidence stick, right? And so if preponderance of the evidence is 51%, right?
No.
You don't like that?
50.1. A grain of sand.
Yeah, a grain of sand. Interesting. So, in other words, more likely than not, right?
Right.
It's just enough to tip you over. So that if that standard is that, then and clear and convincing is the highest, right?
Right.
Then beyond a reasonable doubt is just below that. It just means, can you push every reasonable doubt out of your mind, other than the story being told by the prosecution or whatever the story is that's being told. It's very close to certainty, right? That's how I try to describe it.
But the question is, can you find beyond a reasonable doubt that, right?
Well, the question seems to be, well, just because he has a gun, assuming that's legitimate, that doesn't get you has a gun,
doesn't get you the elements of the crime.
He might be convicted of a gun charge, as in, if it's not his weapon or it's illegal, but that's not shooting.
They can't even prove that.
That's not assault and battery.
That's right. They can't prove it. So then,
so the question becomes elements of the crime. You can't prove one element beyond a reasonable doubt and get you to the finish line.
Yeah, that's all the elements of the crime. And when we were young prosecutors, we were told, bring the book, The Wall Down, with you. Open it to the page where the crime is charged in the indictment.
There you go.
The charge, and you have all the elements, and make sure you ask the questions. And did he have a gun? And did he shoot the gun? And was there a projectile in the gun that was so that you got all the elements in? They told us when we first started out. So
I would describe, criminal law is one of the first classes that anybody has. It's a first-year law school class. The reason is because it's easier for people to grasp, because it's like a cookbook. Let me tear out the page for battery. Oh, here's my cookbook. And here's the elements, the ingredients that I need to make that recipe.
That case. Right.
Yeah.
You're absolutely right. Moon Goddess, again, the Commonwealth did not preserve the original video audio. That's a problem. Yeah, I think all this is a problem.
Yes.
Because let me tell you, you have a duty. We talk about a right to preserve, or a motion to preserve, which I file all the time. Usually when I get into civil cases, I go in under New Jersey. Well, even though they don't have a case, let's say it's a shooting case, not a criminal case. But a lot of times you don't even have a defendant at that point. You can't file a motion to preserve on day one because you're not a defendant. You get no standing. But there's a duty to preserve things that are exculpatory, no matter whether there's a motion to filed or not. So that's a really interesting thing. It doesn't, a motion to preserve only applies to things that are not exculpatory to begin with, that you want preserved.
Yeah, and as the cops are doing their investigation, they know what is or isn't likely to be exculpatory. They don't get to decide whether it is or isn't, but they know whether it's going to be an issue, and they would be required to preserve it.
Right. Candy Temple.
Alan made a great. I'm sorry. Go ahead.
What type of Brady violation? Candy Temple. What type of Brady violation sanctions are available to Bev other than dismissal? Well, she can put monetary sanctions. I mean, dismissal's the biggest one, obviously. Like involvement's the key. That's the one everyone wants. She can put monetary sanctions on the office, right? Yep. She can put monetary sanctions. I don't think she can do it on individual officers, but certainly on the office, on the Commonwealth, and big monetary sanctions on the Commonwealth and all. But that's really the problem. She can eliminate some of the evidence. Some of the evidence can't come in.
Issue preclusion. You've got claim preclusion, and that could manifest itself as evidentiary exclusion. That's not coming in because it's connected to this, and this. Yeah, she has a lot of weapons.
Yeah, that she does. So,
I was going to
but
say
obviously you want the big one.
you want the big tamale.
You
Yeah.
want the big one. You want the big
Alan Jackson
big
made a
enchilada.
great comment because remember the Higgins video that surfaced out of somewhere recently?
Yeah, everything's surfacing out of somewhere.
Yeah. So how does that even exist if, in fact, the 30-day timer had lapsed on this DVR?
Yeah, it's
So
in the
if the DVR
iCloud account.
gobbles everything up after 30 days and starts recording over it, which is not unusual, and it isn't captured somewhere else, how does the Higgins video survive that and come to light after a period of time? It makes you think it is somewhere else, and they have been picking and choosing what they hand out.
That's what Alan Jackson did. That's what he argued. He
Great
said all these
argument,
little
yeah.
clips. It was a very good argument because he said, "Oh, I'm getting all these little things. Where'd they come from? They're not the original. They weren't there. They were gone." You know, Oasis Cat, does it bother anyone else that Bev handwrites her decisions all over the filings? Does she follow up with typewritten rulings? Sorry if the word you didn't word it wrong. It annoys me so much my brain can't think. And most times when you're at court, by the way, you get handwritten decisions on a type because you submit the order and then the judge handwrites on the order. The judge doesn't make up the whole order.
That's a good point.
But they usually write the rulings on.
This is just kind of a housekeeping thing that people may not realize. When the court orders, well, guess where that order comes from generally? The attorney that wins. The attorney, both sides may craft an order, tailored to what they want, and then the court will take the one that closely matches the decision, but it's not always perfect, and that's where the handwritten notes come in. Right. There was that one that Bev just did recently it just confused me. It basically contradicted what she had said. Like the order was denied, but then she hand wrote in something that made it sound like it was granted. And that was very confusing. I wish they had kind of rewritten that instead of had her.
Dizzy. Thank you, Jen. Could she say that the Sallyport video isn't admissible? She could, but the problem with that is that Alan Jackson now wants that in because it showed that they actually damaging. They gave it to him. They had inverted it as to the right and the left, and somebody had to formally do that inversion, and that came out at trial, and somebody must have picked it up and noticed it because I don't think I get the
how stupid could they be?
Yeah,
you see the video and the numbers, the date stamp and everything is inverted. How could you look at that and go, yeah, that's right? I don't understand. And
before that, I thought the witness would testify. They have this guy who was on the stand. I thought, well, he's a pretty good witness. And then it turns out they brought him in there because he was introducing this inverted video as if the lawyers are stupid. But, sometimes you don't see things, too, until, the end, too. I don't know if they saw it.
I guess.
But inverted video, okay.
Well, I mean, the other interpretation is that they saw it, they knew it, thought they could get away with it.
Yeah. Just it's just I don't know, and that leads for the issue of is she guilty or not guilty, because all this other stuff is crazy, right? Just crazy, and it's unfair. Even the supposedly admissions. If somebody admits to a crime, usually we're fighting an admission in a police report because it said, I did it or something like that, or they made an admission, they confessed, and we say, no, you didn't. No, you just made that up. Here, they don't have any admissions in any police reports, and now they're saying, oh, yeah, but we didn't put that in there. We didn't put that in there because we were being fair to her. What?
Yeah, I mean, the whole I did it without, perspective and context. I think one of two things could have happened. Well, one of three things. She really thinks she did hit John O'Keefe. That's possible. She was questioning it. I hit him. Or in the emotion of the moment, she just assumed she hit him. Those are the only three possibilities for her saying, I hit him.
Right. Which doesn't mean she's guilty. Doesn't mean she's guilty.
No. You got to have something to corroborate the other one of those three meanings.
Now, I don't understand how they get around, and apparently, I don't know if there's new expert reports from the Commonwealth. We don't know what they are because they weren't listed in court. But I don't understand, and maybe this is why the federal thing is so important. The federal people, and including the state medical examiner, which of course now we've seen the one from that testified in McGee, said that there was no evidence that a car hit O'Keefe. So if a car didn't hit O'Keefe, how could she have killed him by hitting him with her SUV?
Yeah, I mean that's
riddle me that, Michael Bryant.
That's game over. That's game
then why isn't it game over already? Why isn't it dismissed?
Because you have an expert and you have cops with their various pieces of plastic they found at the scene and in his sweater that they say suggests she did hit him. That's the $64,000 question.
So I'm going to bring that full circle to you.
Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery?
Yes.
It was voluminous.
There we go. Last night.
Okay, then. All right.
Did we have a trial on this case already? Wasn't there a trial already? And Oasis Cat said yes. Bev denied the motion for reimbursement of costs. I don't get that.
I think that's wrong. That's totally wrong, because that's like letting the prosecution off the hook for all of their obstreperous behavior. That money would not have been needed had they been upfront about the things that the expert then had to go and investigate.
Yeah.
So that's wrong. But hey, congratulations, Commonwealth. There's another taxpayer-funded savings for you. Good job.
Right. 12,000 savings while you continue to pay for this trial to go on, right? Yeah. So I mean, that really is. And then they had the thing about the feds, and we're not sure what that is. Probably what's the ARCCA report?
Yeah. Here's how that played out, though, because I think you thought this was interesting. So let's just tee it up so you can see. And we can then speculate about the 14-minute sidebar that took place. Right?
I love speculation.
All right. So the motion regarding, Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Okay. And so, like I said, so that we stared at the profile of Karen Reed for 14 minutes.
Yeah.
So her goal was to find out what was happening on the federal level to impact the state case when it comes to, the ARCCA reports. It's ARR, I think, CA, or it's ARCCA. Anyway, it's ARCCA, but when Judge Bev says it, it's ARCCA. So it sounds like the R is dropped off. And so those are the federal reports, as we're well aware of, that went into the investigation of the collision, if there was one, to determine whether there was one. So what do you think's happening? What's your speculation there?
I don't know. I don't know if they were talking about the ARCCA reports, or maybe, remember, there's that federal investigation that's been going on, right?
Into Proctor.
Proctor. I'm wondering whether it had to do with that, and especially since right now all things are frozen, like with the FBI, right? There's all sorts of things happening. So I'm wondering whether it has to do with the Proctor. Remember, he was supposed to go back. Wasn't he supposed to go back tomorrow?
Like day 2 of his
hearing,
court martial, I call it.
Right.
Yeah.
So I'm wondering whether it has to do with that, or it has to do with the reports at all.
And then she mentioned, are we going to get into the second motion, which was never again addressed because they talked about it at bench. I don't know what the second motion was, but again, it's an ARCCA motion.
Yeah. So
ARCCA related.
Yeah, well, although she has some tight timelines with them that we discussed at lunch, and they have a trial date of April 1st, I guess, right?
April Fool's Day.
April Fool's Day.
Yeah, and the dates, we confirmed earlier. They've moved the date for the fully throated motion to dismiss. That has been moved to I keep misreading my notes here, but I think it's the 21st. Right? Yeah. 21st. That's a Friday. That's when Alan Jackson begged for the weekend, and the judge said, no, thank you.
No, thank you.
So March 4th will definitely be up there for that, because that's going to be full-throated. So got to be up there for that.
So we should look. I don't know. Should look into it. What happened with this? This now goes to the case we've been covering all day, which is
ASAP.
Here's a Karen Reed order. Right. By the way, just looking at it right now. After hearing and pleadings, the court credits the affidavit of special credits, though this is actually interesting before we go to ASAP. Credits the special affidavit of Special Prosecutor Hank Brennen, paragraph 6. Quote, Attorney Jackson expressed concern that the materials may longer exist on the NVR, given the time that had passed since the event. I agreed with him and told him that I had no knowledge whether the material still existed or were overwritten given the passage of time. In light of that, averment by ADA Brennen, and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennen discussed his concerns regarding the likelihood of the video still existing, the motion to recover cost is denied. Further, though Attorney Jackson argued for sanctions for the alleged violation of Mass Rule 14, there is nothing in the written pleading that raises this argument, and therefore the issue is not currently before the court. Order defendant's motion to recover expenses denied.
Yeah. So you have to wonder too.
There you
I mean,
go.
12,000 is 12,000, but in the big scheme of things, it's, it's a soda, in terms of the defense costs in this case. And now that there's a second trial, especially, I wonder if to some degree, AJ was using it as a platform to get out there all of the alleged abuses and misconduct that he says has been perpetrated on the defense by the prosecution.
And he did so brilliantly.
He sure did. And so there's always a motive. So if it was a loss, probably well worth it, right?
Right, exactly. And also, since it wasn't before the court, the issue of the violation, it allows him to bring the motion now again, because she says, well, that what you just argued wasn't before the court, right? And we were saying that he worked his way into it. So
yeah.
I mean, it's really not.
I think it's going to be all part of the motion to dismiss.
Yeah,
all of that.
All of that part of the motion to dismiss. Now,